In the inquiries we did on homelessness and mental illness, it wasn't just human rights NGOs that were important. Many of the people who were actually doing the most effective and important work in the community to care for these groups of people were carer groups. And one of the things that is very important to do, whether we're lawyers or human rights activists or both, is not overlook the fact that the people who are doing very important human rights work in the community often don't see themselves as human rights defenders. They see themselves as just carers. So there are human rights issues going beyond the individual, and there are groups that we need to talk to who don't self-identify as human rights activists. They say, oh no, we're just a group of parents looking after the elderly or looking after, young people with disabilities. It's also very important, I think, not to underestimate or overlook the importance of discussing the terms of reference in advance with all of the stakeholders. Because if you don't incorporate their perspective, at least in the initial discussions, then the reality is that they won't feel ownership of the process of the inquiry, and they won't therefore necessarily participate as much as you would like.
We had a very extensive preparation that involved, amongst other things, focus groups with disabled people, so that we could hear from them in their own environments where they were comfortable to help identify the issues. And out of that process came the original consultation document. Once that the preparation stage was done, we called for submissions in writing, but also orally, in person, over the phone. We tried to be as inclusive as we could, and particularly for disabled people to identify what was the most appropriate way for them to participate. And again, I think one of the things that we learnt was that within limited resources, the more places we could actually go, the better, because it opened up the issues in those communities.
We started networking right from the very beginning. And in our country, there are so many NGOs. So we have been working very closely with them, holding seminars and talking to them, and that they should bring in the human rights aspect to their work. Because after all, human rights is part of life. It's not something coming from Mars or some places. It's with us, you see. So I'm rather pleased that in the past 5 years, we have got a lot of partners.
The government itself generally is very supportive. They want to resolve this issue. According to the Attorney General, when we had this meeting with the Chief Secretary, when he welcomed it, he said, it's good that you have this inquiry because then it will ease the strain on the court. Because otherwise the issue would go to court, and the court would take time, years sometimes, Of course, they said the Chief Secretary did suggest that maybe in the inquiry, we'll bring in top civil servants as well. But when we considered this further, we thought that it's not quite appropriate to have civil servants sitting in our inquiry. So we told the Chief Secretary that because of the independent nature of our inquiry, it's better that we invite the civil servants as witnesses.
With our Indigenous community, with Aboriginal people and Torres Strait Islanders, we found that in some cases they wanted to talk to us as a group, and we went right around the country. We held hearings in about 20 different towns and cities, and we would sometimes literally, I remember in some cases, sit down under a tree and talk to a group of 20 or 30 Aboriginal people about what was happening in their community. And that poses some challenges in terms of having an accurate record of the evidence. I mean, there are all sorts of things that you've got to think about in terms of having transcripts and ensuring that when you come to write the report, you're accurately reflecting the testimony or the evidence that people have given.